The protection given by Article 13 is against which authority? We have seen that Article 13 protects the fundamental rights by way of Clause 1 and Clause 2. These two clauses declare laws as void if they encroach upon any of the fundamental rights. But this protection is against what authority? The answer is that Article 13 protects fundamental rights from the violative action of the state. Clause 13(2) declares that state shall not make any law which abridges or takes away any fundamental rights. So it is the state which has been barred, which has been prohibited from violating the fundamental rights. Therefore, it is an important question as to what is meant by the term state. This term is actually defined in Article 12 to mean the legislature as well as the executive. This is precisely the definition of the term state as given in Article 12. State includes Government of India, that is the executive, Parliament of India, that is the legislature. So both the executive and the legislature are included in the definition of the term state. State shall not make any law, which means the Parliament shall not make any law, the executive shall also not make any law. Now, generally executive does not make law in the sense we understand it ordinarily. That is why the definition of the term law has been expanded by Article 13 Clause 3 to include executive action also. Then the term state includes government of every state and legislature of every state. So it is the executive and legislature wings at the state level, and then all local authorities in India, and lastly other authorities in India or under control of Government of India. Now this last component of this definition, other authorities in India, that is something which is not defined anywhere, and it can take different meanings. The Supreme Court has had several occasions to interpret this term other authorities, and through its judgment the scope of this term has been extended extensively right from the early years. We will study some of these judgments and we will see how this term has been expanded chronologically. The first judgment we consider was rendered in 1967 in the case of Rajasthan State Electricity Board versus Mohanlal. The question in this case was whether the electricity board, the Rajasthan State Electricity Board, which was a corporation constituted under a statute primarily for the purpose of carrying on commercial activities, could come within the definition of state under Article 12. This was a corporation constituted primarily for commercial activities. Could such a corporation come within the definition of state? And the answer given by the Supreme Court was yes. And the reason? The expression other authorities in Article 12 will include all constitutional and statutory authorities. In this case, the State Electricity Board was a statutory authority. The court declared that all constitutional and statutory authorities on whom powers are conferred by law shall be included in the term other authorities. And it is not at all material that some of the powers conferred may be for the purpose of carrying on commercial activities. So even if the authority is carrying on commercial activities, if the powers are given to it by a statute or by the constitution, then it will be included in the term other authorities. Next judgment was in 1975, Sukhdev Singh versus Bhagat Ram Raghuvanshi. The question here was whether the Oil and Natural Gas Commission, the Industrial Finance Corporation and the Life Insurance Corporation each of which were public corporations set up by statutes, were authorities and therefore within the definition of state in Article 12. And the answer once again was in the affirmative. The court said that the concept other authorities would include a public authority, which is a body which has public or statutory duties to perform and which performs those duties and carries out its transactions for benefit of the public and not for private profit. Such an authority is not precluded from making a profit for public benefit. So even if it is a profit-making body, it will be included under the term other authorities if it has public or statutory duties. In 1981, in Som Prakash Rekhi versus Union of India, the question before the court was whether Bharat Petroleum Corporation was a state under Article 12, and the answer once again was yes. The court said that Bharat Petroleum Corporation is a state within the enlarged meaning of Article 12. There is now no doubt that the meaning of the word other authorities has been enlarged considerably by the judgments of the Supreme Court. In 2002, in Pradeep Kumar Biswas versus Indian Institute of Chemical Biology, the question before the court was whether CSIR was a state within the meaning of Article 12, Council of Scientific and Industrial Research, whether it was a state, and the court answered this question once again in the affirmative. And the reason here was that CSIR was under the control of government. The court said that the government control in CSIR is ubiquitous. It's present everywhere. Given the fact that president of CSR is the Prime Minister himself, subjugation of the governing body to the will of the central government is complete. So this is one criteria, one factor is here the control by government, and the other factor is contributions, financial contributions. And here also the court found that non-governmental contributions were a pittance as compared to the massive governmental input. And these were the two reasons why CSIR was held to be a state. And lastly, we consider whether BCCI, the Board of Control for Cricket in India, is a state within the meaning of Article 12. This question was answered by the Supreme Court in 2005 in Zee Telefilms versus Union of India, and the answer for a change this time was in the negative. The court held that BCCI was not a state within the meaning of Article